Thrilled to have you all here with us today for an update on some of the many issues that we're all confronting as we deal with this new world of COVID-19 and stay-at-home orders and all the other things that are happening in our economy today. I'm joined today by my colleagues, Tracey Truesdale, Melissa Sobota, and Jason Patterson. And formal Q&A conversation today, and we asked members of the audience to submit questions in advance of the program today. So we'll start out by going through some of the questions that we received and frankly have been receiving from employers over the past few weeks to start with. At any time throughout the program today, if you're familiar with Zoom, you've probably aware of the Q&A option down in your control bar. If you would post any questions in the Q&A section as opposed to the chat section, that's where we will be looking for them. So please do feel free to chime in with your questions at any time throughout the program. Again, the purpose of this is to make it a little bit interactive and to just try to respond to a number of the questions that we've been receiving from so many of you over the past few weeks. After the webinar today, everyone will receive a copy of the webinar recording. You can feel free to share that with any colleagues who may not have been able to join us live today, or review it if there's questions that you want to refer back to later. You'll also receive a survey this afternoon. We really do appreciate you taking a few minutes to fill out the survey after the program, as it does help us to plan future webinars. All right, so with that, let's jump into the content for today's program. And we're going to address these questions really in sort of phases. So first, we're going to talk about some issues that are affecting employers that are fully or partially shut down as a result of the COVID-19 situation and the stay-at-home orders, some common issues that those employers are facing. We'll talk about employers that are still operating, essential businesses that may be staying open despite stay-at-home orders, and some of the concerns that affect those businesses. And then we'll also talk about what comes next. What should employers be thinking about as various areas of the country look to reopening? What is the workplace likely to look like when we do start bringing employees back? So with that, let's jump right in. So one of the most common questions I think we've been receiving over the past few weeks is, what is the difference between a furlough and a layoff? So Tracey, do you want to talk about that and explain for everybody, how you think of those terms?
Yeah, I mean, there is no real legal definition of a furlough. Layoff has some significance under both Illinois and federal WARN, which we'll talk about in a few minutes. But a furlough generally is a condition where employees, their work schedule is reduced or they're not working for a period of time. In this case, presumably occasioned by potentially a temporary shutdown of the business in connection with the governor's stay-at-home order or a reduction in staff due to that stay-at-home order. But the expectation is once the stay-at-home order is lifted or relaxed and the workplace can start to percolate again, those folks will be returning to their regular jobs and regular schedules. When we think about a layoff, we're notifying employees that they're being released, and there may be a recall at some point, but we're really not clear as to whether those employees will be returning. So it's more akin to a termination, unless of course we're dealing with something like a collective bargaining agreement, which may define certain parameters with respect to layoff and employees' recall rights. But when we're talking about it in a non-union setting, it's usually sort of the temporary reduction in schedule versus a more permanent situation.
Got it. So one of the other questions we've been receiving a lot in relation to layoffs and furloughs is whether it's true that for at least some employees that they may be better off on unemployment than if they were to stay on the payroll, perhaps in reduced hours capacity or with a cut in salary. Melissa, can you speak to the unemployment aspects of this and whether that may actually be true for some employees given everything that's going on?
Sure. It will actually kind of vary. It need to be kind of a case by case determination because employees are eligible for their base benefits, which is calculated by a specific formula set by Illinois law to determine by evaluating the employee's pay history for two of the last four quarters that are when they earn the highest earnings, and then apply a formula to those earnings to determine what their weekly benefit will be. And then if they're eligible for any benefits based on that, then they will also get an additional $600 in the emergency relief under the CARES Act. So in some circumstances, yes, employees will receive additional income or more income while they are on unemployment than they would if they remained employed. But in other instances, they won't be. And there's also additional factors you want to kind of keep in mind as far as the length of the closure and whether you're going to be a chargeable employer for future benefits going forward. So you really want to take a look at it on a case by case basis. There's not one simple answer that goes to everything.
And this can really vary employee by employee too, right, Melissa? For example, based on whether somebody is married or has dependents.
Correct. Yes, because there are additional benefits, slightly higher benefits under Illinois law for individuals who are married with a dependent spouse, as well as employees who have child. They do have some increased benefits.
Got it. Thanks. So one of the other questions that we've been dealing with is if a business shuts down, for example, under the stay-at-home order, does the employer have to issue warn notices to their employees? So the answer to that really depends on the circumstances. First of all, warn notice is generally under federal law and at least Illinois state law, only triggered by employment losses of 6 months or more. So if you are simply furloughing employees or laying them off temporarily, but expect to recall them to work in less than 6 months, you don't necessarily have to give warn notice as a result of that employment loss. On the other hand, if you're permanently separating employees, for example, you're just shutting down operations because you don't expect to be able to meet expenses or to return to business after the crisis passes, in that case, warn notice might be required. And from there, you really do have to look at the numbers under federal law as well as the law in each jurisdiction where you're operating. So remember, under federal law and Illinois state law, as well as the law of some other states, there's also a window that you have to look at when you add up those numbers to see whether you've triggered warn thresholds. Under federal and Illinois law, that window can be up to 90 days. In Illinois, we're generally talking about job actions that are affecting 25 employees and at least 33% of employees at a single site of employment. And this is counted by employment site. Now, one other important point here is that warn notices generally don't apply to government employers, but that is generally. There is a provision in the statute that says warn notices can be required for quasi-public entities, that is, entities that are engaged at some level in commercial activities, and that can be a fairly fact-specific analysis. So, generally speaking, if you're conducting any sort of reduction in force, it is not a bad idea to consult with counsel and determine if warn might apply to the situation. All right. Melissa, one question for you that just came in is that folks it says, I know folks who've received their unemployment check, but no $600 additional. And the question is the additional $600 under the emergency relief legislation for everybody who's receiving unemployment benefits?
Yes, based on the Department of Labor regulations, everyone who is eligible to collect any amount of unemployment compensation is eligible for the additional $600 in emergency relief benefits. I believe the state was supposed to be starting to issue those checks a couple of weeks ago. But as far as anybody in other states, I understand that there have been some substantial delays elsewhere, and there may be some residual delays in Illinois just from the way the system was overwhelmed.
Got it. Understandable. All right. Jason, can you talk about are there any considerations that employers should keep in mind when they're considering furloughs for overtime exempt employees?
Sure. That depends, or there's a distinction here when we're talking about public sector employees and private sector employees, as far as furloughing exempt employees. When it comes to private sector employees, under the department's regulations, you can furlough them for a full work week. If you go beyond that point, you risk, or you could jeopardize their exempt status, which opens up another host of issues. As far as public sector employees, there's a special rule that does allow furloughs of less than a week. But as always, under the regulations, there's no teacher salary requirement when it comes to that set of public sector employees.
Great. And it is important to keep in mind that there are other steps that employers can take if the salary basis requirements are an issue in taking whatever action needs to be taken with respect to exempt employees. The Department of Labor has a fact sheet that explains some of this, and one of the points made in that fact sheet is, for example, you can prospectively reduce an exempt employee's salary as long as you're not using that as a way to evade the salary basis requirements. So, there are options that employers can pursue, even with respect to exempt employees. Tracey, when an employer is conducting a furlough or a layoff, do employers have to pay out vacation or PTO time that an employee might have accrued?
For under Illinois law, Illinois Wage Payment and Collection Act speaks to the payment of final compensation upon separation. So if we are equating a layoff to a separation from employment, in that circumstance, yes, PTO and vacation time should be paid out. If we are furloughing employees where their work is temporarily interrupted, but we expect them to resume full employment once we're out from the stay-at-home order, then you wouldn't, our view is the payout is not required because there has been no separation from employment. Now, from a business perspective, whether you want to allow employees to use that time during the period of furlough, that's going to require some weighing of pros and cons. There's no requirement that employers allow employees to use their vacation or paid time off during a period of furlough, although I certainly would recommend that employers communicate that position to employees when they are furloughing them to make it clear that during this extreme period of shutdown, that time won't be available to them. But bear in mind that if you are unable to bring everyone back at the end of the stay-at-home order, you may have a fairly substantial chunk of time that needs to be paid out for a number of employees. So it may be in your best interest to allow employees to continue to chip away at their vacation and PTO entitlement, and it's also it eases their burden as they're idled, for the foreseeable future.
Absolutely. Now, Melissa, when an employee or an employer is paying out vacation or PTO, does that have any interaction with an employee's eligibility for unemployment benefits?
Absolutely. So vacation payout is considered disqualifying income. So it will offset any unemployment benefits the employee may receive. And you need to keep in mind, if the vacation payout is more than the employee's weekly base unemployment benefit, they will be prohibited from collecting any unemployment benefits until they're done being paid for their vacation time. And by being denied the base benefit, my reading of the DOL regulations is that they will also likely be denied the additional $600 in emergency benefit. So it may make some sense for employers such as those who are only looking at a very short furlough, may make sense for them to pay out the vacation so they're not on the hook for any or the chargeable employer for any unemployment compensation down the line. But in other instances, it may not make sense to pay out the vacation time if the furlough is going to be extended and you want your employees to be able to collect unemployment benefits as well as the emergency relief benefits.
Got it. Tracey, are there any special considerations that employers need to take account of when furloughing or laying off union employees?
Yes, I mean, clearly the employer needs to be mindful of any restrictions on its ability to lay off or to furlough under the collective bargaining agreement. And in the public sector, also need to be wary of any statutory limitations on the ability to lay off or furlough. And in the collective bargaining settings, even if the collective bargaining agreement allows employers to reduce the working forces, to determine the number of employees that it will have on its payroll, there's still likely going to be an obligation to bargain over the effects of that layoff and its impacts.
Okay, thanks. So, Melissa, I've heard a lot of questions from employers about how unemployment works when an employee is not laid off or furloughed altogether, but for example, they may have their hours cut substantially, or an employer may be considering an alternating furlough, say having part of the workforce furloughed for a week or 2 weeks at a time and then coming back on. Under those circumstances, are employees still potentially entitled to unemployment benefits?
Yes, so it will vary, but any employees who have their hours or compensation reduced due to the crisis are eligible to apply for benefits. If they're working part-time, for example, their base benefits will be offset by whatever their part-time compensation is. So you do want to keep that in mind, because if you do want employees to be eligible to collect some benefits, you'll have to look at each of their individual calculations for their base benefits to determine whether the amount of money you're paying them would disqualify them from collecting any unemployment benefits. Because if they are earning more than their base benefits, they will not be eligible to collect unemployment compensation. Additionally, for an alternative work schedule, the individuals who are returning to work for whatever week that is, and they're assuming they're paid their regular wages, they would not be eligible for benefits for that week.
Okay, so when you say an alternative work schedule, you're talking about somebody who's on an alternating furlough, right, and they come back to work for that period, they would not be entitled to benefits.
Correct, provided they're working full-time. Now, if
Right,
they're working part-time, then you're going to look at the offset again.
Okay. And then if an employee on one of those alternating furlough situations, if they then go back out on furlough again after another 2 weeks, would they potentially be eligible for unemployment benefits again once they're back out?
Yes.
Okay. Now, do employers have to, obviously employers have their reporting obligations to IDES. Do employers have to do anything additional with those employees to make sure that they're entitled to benefits when they go out again for a second time or beyond?
There's a notice that employers are supposed to provide to employees whenever they're being separated from their employment, whether it's a resignation, termination, furlough, layoff, etc. They should be providing those notices to employees. I don't think IDES, based on their current caseload, is really tracking whether employers are sending that information out or not. And I don't under the handbook, there's really not an enforcement mechanism to it either. But I think as long as you provide the employees with that notice at some point prior to or shortly after a layoff, a furlough, or whatever, and you've provided it to them at least once, you should be fine.
Got it. So, question that just came in again about unemployment. So, what about a situation where the employer has told employees, salaried exempt employees, non-union employees, that they'll be furloughed for X amount of days over a 2-month period? The employees can pick which days not to work and to be unpaid. Is there no possibility for unemployment in that situation?
Again, if their wages are going to be reduced, which I'm assuming because you're doing some sort of at least partial furlough, they will be their wages will be reduced at least at least some. Then they will be eligible to apply for unemployment benefits. However, again, you're going to do that calculation, or the IDS is going to do the calculation as far as what their base benefit amount would be and whether what they're being paid on a weekly basis exceeds that or not. If it exceeds it, they won't be eligible for benefits. If they do not exceed their base benefit, they will be able to collect whatever the offset amount is, plus the $600.
Right. So if we're talking about a furlough day here and there, maybe a day a week or something along those lines, fair to say it's probably not likely to trigger eligibility for unemployment?
Probably not, especially if you're more highly compensated employees, because the maximums under state law are still pretty low. So if you have a more highly compensated employee, they're still probably going to be exceeding the weekly maximum benefit under state law, so they wouldn't be eligible.
Got it. And one other comment on that question, it specified that the employees at issue are salaried exempt employees, not part of a union. If this is a public sector employer, and this was an anonymous question, so if this is a public sector employer, that may be fine. If this is a private sector employer, you may have an issue because, again, you do have to pay employees, exempt employees, their full salary for any work week in which they do any work, as Jason explained earlier. So that particular setup may not work for a public or for a private sector employer. All right. Melissa, another question relating to unemployment. We're still paying employees, but received a notice of an unemployment claim from the employees that are still on the payroll. What should an employer do in that situation?
So you'll want to respond. I mean, I've seen this question actually come up quite a bit because a lot of employees, whether their full-time regular employer knows it or not, a lot of them have either their own independent businesses on the side or other part-time employment and that type of thing that they may no longer be working and would be eligible for benefits based on their prior or their additional employment. Typically that's the majority of the cases that I've seen come in where this has been the situation. However, whenever you are still paying an employee their full wages, or actually any wage, their full wages, you should definitely respond to the notice that you get and indicate there's like a little check mark box on either the back side of the paper or on the second sheet of paper where you're responding and it says employee is still fully employed. So you want to make sure you check that. Ideally, you want to return that back to the IDES within the time frame that is for a response that's set forth on the front of the page. But you can respond to that at any point in time, even if you miss that window. So you definitely want to do that. And also keep in mind, if they're part-time employees of yours, they still may be eligible for some benefits.
Great. Another unemployment question came in. So what is the obligation of a union employee to return to work if work is available for them? Does the employee's failure to accept shifts if a full-time employee affect the employee's eligibility for unemployment? And is the employer required to report this?
Okay, just want to make sure I understand the question. So if you have offered an employee the ability to either return to work in a full-time capacity or whatever their regular capacity is, and they have voluntarily declined to accept that offer, they are not eligible for unemployment benefits. However, a little caveat in these unique situations, if you have an employee who says they cannot return to work for a qualifying reason, such as they have a dependent child or family member in their home who is unable to go to school or a care facility because it's been shut down due to the crisis, and there's no one else in the home that is able to care for that dependent, that individual may be eligible for unemployment benefits. However, yeah, go ahead.
Right, and the other qualifying reasons, for example, would a qualifying reason be I'm concerned about my own exposure to COVID, even though I'm not necessarily in an at-risk group, and so I'm declining on that basis?
That I don't believe would be covered. I believe the another caveat would be if an employee has been told by a medical professional that they should, because they're in a specific group or have otherwise high exposure to it, and they are told that they should self-quarantine, they would also qualify for unemployment benefits if they're experiencing symptoms and they are trying to seek a diagnosis. They would be eligible for benefits. So you're just going to need to look at each individual employee situation on a case-by-case basis.
And in those situations, I think it's also important to add that many employees, at least if they are working for a public sector employer or an employer with 500 employees or with less than 500 employees, I should say, may be entitled to leave from work under the Families First Coronavirus Response Act. Now, not every employee is covered if you're working for a larger private sector employer, but some of those same qualifying reasons that may entitle an employee to unemployment benefits would also trigger the obligation to provide leave under those new emergency leave statutes. And am I correct in assuming, Melissa, that if somebody's receiving paid leave under one of those leave statutes, they would not draw unemployment during that time?
That's my understanding, because they would be considered in an employed status.
Okay. All right. Let's shift gears a little bit. We've been talking quite a bit about unemployment, and certainly if you do have more unemployment questions, feel free to send them in and we'll do our best to answer them. But let's shift gears now and talk about employees who are reporting to work during this shutdown period, during these stay-at-home orders. So, and reporting to work these days can mean actually physically reporting to a job site, or it can be exactly what the four of us are doing right now, which is working from home. And I suspect many of you in the audience may be doing exactly the same. You may be aware that effective January 2019, the Illinois Wage Payment and Collection Act was amended to provide that employers are required to reimburse employees for business-related expenses. And so one of the questions that comes up in that context is, okay, now that we're telling everybody that you need to work from home, do we have to start reimbursing employees for their home internet and phone service as long as they're working at home? Now, used to be that the answer to that was, look, if an employee is working at home for their own benefit because it's more convenient for them, then the employer can fairly easily say, look, we have everything you need here in the office. If you choose to work from home on the weekends rather than come in, that's fine, but we're not going to reimburse you for your internet service because it's not a necessary business expenditure. We already have internet service and phone service here at the office. Well, that's not an option at the moment, working in the office for a lot of people. And so there is definitely a question under the Wage Payment and Collection Act as to whether employers should be reimbursing for some portion of internet and phone service. Now, we don't have clear guidance on this from the Illinois Department of Labor right at the moment, but some court decisions interpreting similar provisions in other states like California have said that, look, even if the incidental business use of, say, an employee's home internet connection doesn't actually increase the employee's internet bill, they're still paying the same bill to Comcast or AT&T that they always have. They're just happening to use some of their bandwidth for email and business purposes now. Even in that case, the employer may still have an obligation to pay some reasonable proportion of the total cost. Now, the Illinois courts, to my knowledge, haven't yet issued that ruling, but I don't think it's an unreasonable, whether it's reasonable or not, I don't think it's an unlikely position for them to take. So an employer's best approach to this may well be to adopt a policy that provides some allowance, pick a number for paying a portion of employees' connectivity, and you could lump in mobile internet, mobile data, mobile voice, and home internet service, and just provide an allowance to employees, and then also provide a opportunity for employees who feel that the allowance doesn't sufficiently compensate them for any additional expenses to have a way to claim or submit for those expenses. If your policy is well written and requires documentation and requires advance approval for expenses beyond the allowance, that can provide you a defense to any later claims that an employee may have that you didn't provide adequate reimbursement. So if you don't already have a solid expense reimbursement policy that covers this eventuality, that definitely may be something you want to look into adopting. Certainly work with your employment counsel on putting that together. And also keep in mind that in the public sector for union employees, this may well be a bargaining issue. So it may be something that you're hearing about from your unions. And again, talk to your legal counsel, your labor counsel about how to address that and, whether or not this is a topic that you should be raising with your unions and when. All right. Another question we get in when we're talking about employees working from home is, employees who may, for whatever reason, not want to work at home. So, suppose an employer is giving employees the opportunity and they're providing the resources that they need to work from home. But an employee says, look, I don't want to work from home. That's not the deal I signed up for. In that situation, Melissa, can an employee collect unemployment?
Generally speaking, no. So if you offer an employee the ability to work from home, unless they meet one of those other caveats, such as caring for a dependent child, the other issues we talked about a few moments ago, if they decline a reasonable work opportunity to work from home, they are not eligible for unemployment benefits because they are not actively seeking work.
Got it. A follow-up question to the point about reimbursing employees for their work-at-home expenses is, what if a private employer gets to the point where it cannot afford to pay for those work-at-home expenses because of how small the employer is, and the only option is to furlough the employees? Well, I guess, first, I'd take a look at how significant the work-at-home expenses are in terms of your overall payroll. We may be talking here, out of a typical home internet bill. I don't want to quote an amount as to what would be, quote unquote, reasonable, because I don't know what your business does or how often you're requiring people to get on video or upload large files. You'd have to look at actually what you're having people use their internet for and, what their reasonable expenses would be. But we're probably not talking about a huge sum of money here. And in the context of your overall payroll, I would be surprised if that amount of money is what's really creating the cash crunch for your small business. I'd say if you're not able to meet that amount of payroll, you probably have bigger problems. But if it really is that is pushing things over the tipping point, then unfortunately the answer is, according to the Department of Labor, business expenses are now wages, and if you can't afford to cover your wages, you shouldn't continue to operate. And so then the only option may well be to furlough employees who you can't afford to pay their appropriate wages, which again include those business expenses. All right. Something else that's come up, and this starts to get into a major topic of discussion for obvious reasons right now, which is employee safety. And so one of the safety measures that we've heard some employers requiring of their employees is to tell employees who are required to report physically to a work location that, look, we want you here, but we don't want you to use public transit to get here because of the risk of exposure while you're riding on public transit. So is that something that employers can do? And if they can, what should they be thinking about? For example, what about the travel expenses? Tracey, do you have any thoughts on that?
Sure. There's nothing under Illinois law that we're aware of that would prohibit an employer from limiting an employee from in terms of their mode of transportation into the office or into the work location. And, a ban on using public transportation is probably a very reasonable request at this point. Although, your ability to police that and enforce it, I think is questionable. Obviously the caveat that has to be put around that is whether there's any collective bargaining limitation on, your ability to dictate how an employee commutes to and from work. I think the bigger issue is if you do dictate the mode of transportation and you basically are relegating employees to, in many cases, drive. I mean, the weather is getting nicer. You might be able to have folks walk or bike to work. But if they're coming any, significant distance, they're going to be driving to work. So while you may not ordinarily reimburse parking and, mileage expenses, those may be expenses, now that are reimbursable under the expense reimbursement requirement of the Illinois Wage Payment and Collection Act. So that's something to bear in mind as you direct employees how they should be coming into work.
Absolutely. An attendee asked, can your policy state that employees who choose to telecommute are not entitled to an allowance? So yes, and ordinarily, again, if we were asking this question 2 months ago, then I would say absolutely. If an employee is choosing to telecommute but not required to telecommute, then that's not a business necessity. Right now, it depends on, first of all, is the employee, for example, in Illinois, where we have a stay-at-home order, is this an essential employee? If they're not an essential employee, then the only option they may have to work is telecommuting. But assuming they have the option of coming in and reporting to a physical work location, I think, yes, the usual guidance would probably still apply if it is the employee's choice to stay at home and telecommute from home when they have all the resources they need to work from the office. I would just think about your workplace policy and whether, if you have employees who are able to telecommute, is it a good idea right now to have them reporting to work, or to make the issue of whether you reimburse them for their telecommuting expenses, on a temporary basis, the reason that somebody is feeling that they need to be coming into the office. And again, that's not an answer that will be the same for every organization. So you really have to look at your own specific circumstances. But it is something that everybody, just from a safety standpoint, should be thinking about now. All right. And on the telecommuting subject, another attendee asked if an employee is a nonprofit with only 4 employees, all employees are working remotely. What if an employee doesn't have internet at home and it's needed to work remotely? Does the employer have to pay for their internet? What about if other employees then complain their internet is not being paid for? Again, I think it comes down to, if it is a necessary business expense, then you may have an obligation to reimburse for it. Now, you may establish caps, and you may work with the employee to figure out what a reasonable reimbursement allowance would be. If you're providing home internet service that employee is then going to have access to and use for their personal resources, you may not be obligated to pay for the full amount. It is something that you can work with the employee to make the expense reasonable. But if you are requiring it, then yeah, it may be a required expense. Another question asked about reimbursement. Okay, so we're talking about internet connectivity. Well, what about reimbursement for equipment like monitors? For those who state working off their laptops is creating a challenge to work remotely. In that case, I think the employer gets to decide whether the employee really needs a second monitor in order to work for them from their laptop. If you're going to tell them, look, we're not sending you a monitor, we're not paying for the monitor. If you choose to have a monitor for your own personal comfort, we're not going to call that, you're welcome to use it, but we're not going to call that a business expense. I think you may be able to take that position, but you do have to give some thought as to whether the job duties that you're assigning to an employee can reasonably be performed off of a small laptop screen. If you're asking somebody to do, like we do as lawyers, review gobs of documents and, move stuff around, you may really need a second screen, and a laptop may not be a viable alternative. So you really have to look at the situation individually. All right. So one of the big topics of conversation that we've heard from a lot of clients these days, and it's also the latest fashion accessory, is masks, face coverings. So we know that some states, like New York, for example, have mandated that employers actually provide masks to all essential employees who are still working. And some municipalities here in Illinois have done the same. And so that raises the question, even in jurisdictions where masks may not yet be required, should employers be requiring some kind of face coverings? What policies should employers adopt? So Tracey, do you have thoughts on that question?
Sure, and unfortunately, OSHA, which really governs this realm, hasn't given us a lot of insight about what we would call really the handmade or the homemade face coverings. And I would distinguish those from a mask, because really the way I think the governor has talked about masks, and certainly the way that OSHA treats a mask, is something that is commercially manufactured. It is a KN95. It's a surgical mask, which OSHA has a very specific term for. It's called a filtering face piece. And it's basically a manufactured mask that's made of one single kind of fabric. And so the device filters out particles by using that one kind of fabric. When we're talking about homemade face coverings and employers requiring them, there's a couple of considerations. Number one, because OSHA has not worked to fill the void about how we treat those. When employers use something like a surgical mask, or require, I should say, something like a surgical mask or an N95, OSHA says that there is a modified or a duty to adopt a modified respirator program, which most employers who are finding themselves operating under these conditions, whether it's outside of healthcare, I should say, or first responder, but like a law firm, an accounting firm, a grocery store, these employers don't routinely have respirator programs. And so to put them in the realm of having to provide medical fitness testing for face coverings, is going to be onerous. The other consideration is not everyone, even if you don't do the examination, not everyone is fit to wear a face covering. So the ADA says, and certainly the EEOC has said that you're going to have to do an accommodation analysis for someone who is unable to wear a face covering because of a medical limitation. So what we have seen, certainly the CDC say, as well as most of the guidance, the City of Chicago's Department of Public Health has guidance, and the phrasing is very careful. It says employees should wear masks versus employers should require, or employers must require the wearing of masks. Now, I think that the local ordinances that we've seen or orders that have popped up Skokie has adopted one, Oak Lawn, Tinley Park, Wilmette. They are directing that the public at large wear a face covering, and then also, wear it into the workplace. And so again, the onus is on the individual to make sure that they have what they need versus the employer, as the state of New York has done, is imposing it on the employer, because the employer is going to have some difficulty coming up with enough and coming up with the right kinds of face coverings to protect its entire workforce. So it's a challenging area right now, to say the least.
Got it. So if an employer, Jason, if an employer does decide to require masks, do they then have to provide or at least pay for the masks or face coverings that an employee is going to wear?
Well, at least in Illinois, not yet. However, if the employer does mandate that employees are required to wear these type of masks, or if there's some type of other government or governor order that's requiring the use of masks by employees, there's at least an argument that under the Illinois Wage Payment and Collection Act, that's a reimbursable expense that the employer would then have to pay for its employees. So that's something to at least keep in mind for now. Got it.
And Tracey or Jason, with respect to OSHA requirements, if an employer is requiring certain, if it is considered PPE, is there any obligation for the employer to actually provide the equipment at that point?
Well, the good news is that is the one statement that OSHA has made, which is that OSHA is not considered PPE. I'm sorry, the OSHA said that not a filtering face mask, a homemade face covering is not PPE. So you don't have to undertake PPE analysis to determine what the hazard is and what's the appropriate PPE to be provided.
Okay.
So they have, it's kind of buried in some other guidance. It's a one sentence declaration, but yeah, that's what they've said about that.
Okay. So if an attendee asks if an employer requires masks and an employee doesn't wear the mask, can they be disciplined?
Again, I think you're going to have some issues to the extent that there's an objection based on a medical reason. And, potentially there could be a challenge to whether the employer is complying with, OSHA requirements with respect to the respirator standard. But separate and apart from those, I suppose if the employer is mandated and there's not some sort of a health concern on the employee's part, discipline would be appropriate.
Got it. Another topic of discussion on the safety side has been this question of whether employers should be screening employees to see if they have fevers as they report to work in a physical workplace. Tracey, do you have any thoughts on temperature monitoring at work?
Yeah, I think that, employers may think that temperature monitoring is an easy, quick way to sort of keep track of whether folks are fit to come into the workplace. But there are some considerations that need to be borne in mind as we move, to that environment as folks start to come back into the workplace, or for those, on the phone who have essential workers who may be considering this or conducting it. Number one, you have to have the appropriate equipment, and the folks who are operating it have to be trained on how to use it, because you want to make sure that you're getting accurate readings. Number two is obviously the social distancing aspect of it. There needs to be enough space between the individuals being monitored and between each other as they're being monitored, as well as the person who's administering, the device if they're using a temperature gun, for example. But you want to make sure that there's, appropriate social distancing in that situation. Another consideration is because taking someone's temperature is considered a medical test, and EEOC has said in these circumstances, we are going to relax our examination of, whether that test is job related and consistent with business necessity, given the pandemic. The results of the temperature taking must be kept confidential. And, you may think that's fairly easy. We'll just log it as the temperature is being taken. But, a lot of these temperature guns, they give off an audible alert, or they give off a light alert. Some, they code yellow or red if someone tests positive. So if the person behind them, hears, oh, Joe just, tested at 101 fever. Now we've got an issue because that individual's medical status has been shared with other employees. And then, the fourth consideration, that we may encounter is there's a wage hour component to this. And it's equivalent to sort of donning and doffing in the food manufacturing industry. So when employees are waiting in line to get their temperature taken, that is compensable time. And if an employee waits in line and gets to the front and they test with a fever, that time is still going to be compensable. So all those things are considerations employers should be bearing in mind.
Tracey, we're getting a note that you cut out for a second. Can you repeat what you just said about compensable time?
Sure. The time spent standing in line and having the test administered is paid time. So even if the employee gets to the front of the line and it turns out that they test positive for a fever, they have a measurable fever, that time is going to be compensable. And if you have a collective bargaining agreement, it could be, you could be paying for some amount of show-up time.
Great. An attendee asked, if testing becomes available, can employers mandate COVID-19 testing before employees return to the workplace? I think the first part of that is a big assumption right now that widespread testing is going to become available, at least for the foreseeable future. From a practical standpoint, you're never going to be able to mandate COVID-19 testing because the only people getting it are basically those who are on their way to the hospital. But at some point, the hope is that there will be widespread testing. So, assuming that comes to pass, Tracey, do you have any thoughts as to whether an employer can require an employee to be tested before they can return?
I think the EEOC would actually be on board with that, at least during our current state. But again, I agree with you that the testing is just not going to become widely available. The CDC certainly has guidance that contemplates, the concept of being tested before exiting, self-isolation or quarantine. But whether that will ever, become a reality, I just don't see it happening.
Right. Melissa, when we talk about these safety provisions, are there any additional considerations, whether it's temperature taking or requiring employees to wear face coverings or masks? Are there any considerations that employers need to take account for union employees that may not apply elsewhere?
Well, anytime you're dealing with something where you may be looking at potential disciplinary consequences or something that could impact their wages or be an expense to employees, you may have a bargaining obligation to the unions prior to or as you implement those changes.
Great. Now, one of the things that I think, unfortunately, a lot of employers are going to deal with, if they haven't already, is what to do if you have an employee who reports that they've actually tested positive for COVID-19 or been diagnosed with COVID-19. What steps should you take? Tracey, do you have thoughts on that?
Sure. Yeah, I mean, the employee who tests positive, the recommendation from the CDC, and I think it's pretty universally, agreed that individual who tests positive should self-quarantine or self-isolate for the recommended period of 14 days. So they can do that at home, and whether they can take vacation, or I'm sorry, not vacation time, sick leave to cover their period of absence, and or potentially time under the FFCRA. That may assist in their time off. The second consideration, other than sanitizing their work environment and making sure their workstation, is clean, is to notify other employees that there's been a positive test of someone in the workplace. Now, that information should be shared only with those that have a need to know, sort of those in their immediate work area. So, if you're talking about a company with 300 employees working on 4 floors, floors 1 through 3 probably don't need to know if the employee works only on floor 4. So you want to share it with those individuals. The identity of the person testing positive should not be shared without that individual's express permission. And I would, recommend that you get that authorization in writing, whether it's, they sign something or they confirm it in an email, but something that allows you to share their identity. And if they don't want it shared, then you have to respect that, because again, that's an ADA issue, and the employee is entitled to have their medical information kept confidential. The other thing that employers should bear in mind, if you are an essential business or an essential operation under the governor's stay-at-home order, is the amendment to the Illinois Workers' Compensation Act that went into effect last Thursday, the 16th, which basically says that if you have an employee who contracts COVID-19 and they are either a first responder or they work in an essential business or an essential operation, those individuals are presumed to have contracted COVID-19 in the course of their employment. And it's going to be, the burden is going to be on you as the employer to prove otherwise once we get to a workers' comp hearing. So what we're recommending for employers in those segments of the business community is to go ahead and document those reports on your Illinois Form 45. You want to capture that information at the time it's reported and not try and recreate it weeks or months down the road. And there's nothing incriminating about putting it down in your Illinois Form 45. So bear that in mind. But to document that illness, and then I believe the requirement under the workers' comp statute is if the employee misses 3 or more scheduled work days, then the employer has an obligation to notify the Illinois Workers' Compensation Commission. So, make sure that if you fall within the stay-at-home, if you're an exception under the stay-at-home order and your employees are still working, that you are aware of that recent amendment to the comp statute.
Great. A related question that just popped up. Do we need a return to work clearance from a doctor after a 14-day quarantine for a positive COVID-19 test?
I think that, again, that answer is going to be dictated by the availability of getting a doctor's note. Certainly the guidance that's out there from the CDC and the EEOC to employers is to be flexible about what that documentation will look like. It may not be a personal note from their internist, telling you that they can return to work. It may be an email. It may be, a sort of a standard form that the doctor's office, faxes out that clears that individual. And it may be something that they're given at the time that they test, or I'm sorry, with their test results, that says, once this person is off work for 14 days, they're good to go. But yes, employers are going to, they can require some sort of documentation, but what it must look like needs to be flexible.
An attendee asked, how can you notify other employees who came in contact with the employee who tested positive if you can't disclose the identity of that employee? And I'll field this because I've had to deal with this situation for a couple of clients. Short answer is it's tricky. You do your best. And so it can just simply be a notice that we've been notified that an employee who, we're not identifying out of respect for their privacy has tested positive for COVID-19. We're notifying you of this because you may have been in contact with this individual, and, advise them of whatever precautions you're advising. But, don't use the other employee's name, and to the extent possible, avoid disclosing other information that would sort of out that employee. At the end of the day, if there's only one person missing from work and everybody can sort of triangulate who it was, there may be nothing you can do, but you have to do your best with the situation and try to protect the individual's privacy as best you can. All right, now we only have a few minutes left in today's webinar, and please do, if you have additional questions, feel free to continue submitting them. We'll try to get it to as many as you can. But before we end, I do want to look forward a little bit to the day that the stay-at-home orders are lifted, and we can start to think about reopening some of our workplaces. So, Jason, let me ask this of you. When places of business and public venues start to open back up, what kinds of precautions for employees do you foresee people adopting?
Sure. There's a couple of things that I think employers can consider. One being, to the extent possible, maintain remote work if it's feasible and you're able to still meet your business objectives. That is one way to kind of slowly transition back into something more normal. Going along with that, to limit some of the personal contact amongst your workforce, you can consider staggering your work schedules Again, to the extent possible, maybe rotate those who are working in the office with those who are working out. Obviously, in some industries, that's just not possible, but to the extent that it is. Also, reduce a lot of the in-person meetings. I know here in our firm, we're doing a lot of just Zoom meetings and things of that nature, and they're working fine. There's some meetings that lend themselves to that type of electronic setting. And also keep close tabs and cleaning your more common areas. So your lobbies, your lunch break rooms, conference rooms. If there's a reason that you can kind of keep them closed, that might be an option, but it's all about limiting the amount of traffic in those areas. And also you can reconfigure your office to provide greater separation amongst your employees, again, if that's a possibility. And one final thing you can do is limit the amount of individuals coming in from outside of your organization to visit to what's necessary. And if you have clients that you can handle calls or Zoom conferences, that could be another avenue for that.
Great. Obviously the advice is going to differ from workplace to workplace. The CDC, public health officials have a lot of guidance out there for specific sorts of businesses, schools, other kinds of operations that you should continue to pay close contact to. We're the lawyers, so we look to those experts for guidance, and our guidance is generally listen to what the health experts are recommending. Couple last questions here, and then we're going to close out. One is a prediction. So when restrictions start to be relaxed, do we feel masks will be required by local government in Chicago for employees to return to work? Your guess is as good as mine. I think there's a decent likelihood of it, but I don't have any particular insight on what the city of Chicago may be planning in that regard. And lastly, what if there are only 2 people who share an office and one of those in that office tests positive? How do you inform the other person without saying, and can we put the other person on a 14-day quarantine? Yes, you may want to recommend that both of them self-quarantine for 14 days. How do you inform the other person without saying? May not be possible. And so that, again, the ideal situation is you get the person who tested positive's written permission to share this information. Hopefully they're close enough with their office mate that they'll be willing to share that information. But, realistically, the other person's going to know because there's only 2 of them. So again, you have to do what's possible. And that's really what we're working within the realm of. We can't get, we have to worry about the technicalities just to some degree, but sometimes, the various demands conflict. And at the end of the day, safety and health are the most important things. So we look to safeguard those first, and we'll worry about the rest once those things are taken care of. So with that, we want to thank all of you for joining us for today's webinar. We are out of time. If you do have questions that we didn't get to today, please feel free to contact any one of us, and feel free to list those in the webinar survey that you'll receive afterward. If we do continue to get enough questions, we can certainly schedule another one of these webinars. More than happy to do that, and really appreciate all your time and attention. Again, your feedback on that survey is very much appreciated. So with that, everyone have a great afternoon, and stay safe and stay healthy.